we are dealing with this question of language. All languages are important. In my opinion, I will not say that Hindi is not important or the regional languages. In fact, we should provide opportunities for the promotion and cultivation of all languages in our country. In this connection, I would say that while there should be a common language, it will take a long time before Hindi becomes a language of use in many parts of India. The argument has been given again and again that while Hindi gives an advantage to the Hindi speaking areas, those parts of the country which have absolutely nothing in common with this language will take a long time before they accept the change. That point is very vital to the translations, to the imposition of these books of Hindi on non-speaking people. Therefore, all that I can say is that you must go about cautiously because Hindi is going to be a common language for the country, and in translating books into Hindi and in giving such books to the people, we must be very careful that the terms that are commonly accepted by all should be adopted. In this connection, I would request that while this work is going on, we should not try to translate literally commonly accepted terms from one language to another, whether they have common from the English language or from Sanskrit should be checked. The issue that we have to face clearly is this: when we have a developing system of education, when year by year the number of students in our schools and colleges increases by billions, it is not possible to keep the standards we had when our college going numbers were very small. At the same time, it is necessary that the standard not merely in colleges but the standard of knowledge, of information, of critical value must continue to rise if democracy has to function. And therefore, it is not merely a question of producing textbooks. It is a question of producing good books, and good books in ample numbers to be made available at cheap prices to people who are educated. Actually, we come back to this question, that is the problem of continuing to educate the educated. It is not merely a question of educating the people in colleges, because science is daily progressing. Research work in social sciences is daily improving in economics, in history, and in all these subjects. There are daily improvements in knowledge. The fact that you took a degree or came through a university with which distinction some time ago does not make you an educated man. It is necessary that you should keep in touch with those things so that the standard of knowledge continues at all levels. President himself, then the scheme which was envisaged in section 93 of the Government of India Act would have been copied in the Constitution. The very fact that it has not been done clearly shows that the framers of the Constitution expect Parliament to exercise the legislative power and only in exceptional circumstances should this power be delegated to the President or to any authority to be named by him. This was, to my mind, the real intention and the real scheme as it is envisaged in the Constitution. But what do we find? Whenever there is a proclamation, automatically this bill is brought and passed by Parliament and the powers are vested in the President. What is the necessity of the ritual to be gone through at the time of every proclamation, whereby the Parliament might divest itself of its power the moment it has got it? There seems to be no sense in this type of ritual to be gone through after every proclamation. It has been stated that this becomes necessary because of the fact that Parliament might not have sufficient time to consider the various bills, and therefore it is desirable that this power should be vested in the President. Again, I ask the same question. Were not the framers of the Constitution aware of the fact that there was the function which Parliament had to perform regarding the central government, and that Parliament might not find time to look into the legislative matters of the territories? So, after long discussions, we are about to pass this bill. Many of our suggestions have not been accepted, and we shall continue to press them in future whenever we get a chance. As you know, even before this measure came, I brought in an amendment to section 293 prohibiting donations to political parties. We may do it from this side of the house through private members' bills. Now I will make a few suggestions. Whatever little improvements have been made, despite the fact that they have not gone very far at all, very much will depend on how the law is administered, and we find from our experience that whenever a measure of this kind is passed containing neither so bad nor so good provisions, they are not properly implemented. There are certain provisions in the bill which are important and they should be enforced. we can enforce them. Sir, great responsibility devolves on the Department of Company Affairs. In this connection, you will have noticed that in the course of the discussions, none from this side or from the other side of the house the Act of 1998 was a step in the right direction, a step in accordance with the Convention of the ILO, which makes it necessary that minimum wages should be fixed. This act was a remarkable piece of legislation because it provided protection and help to workers who were, by the very nature of their employment, by the very nature of the industries in which they were employed, not in a position to organize themselves sufficiently strongly, were not in a position to win a minimum wage for themselves by their own organized strength as workers in the Ahmedabad and Mumbai textile industry did long ago. The Minimum Wages Act was an act to help the poorest, the most downtrodden sections of the toiling population of our country. Many industries in this country were prospering on sweated labor, and this act made it necessary for them to pay minimum wages. The concept of equality has been derived from preamble of the Indian Constitution, which guarantees equality of status and opportunity, and Article 14 of the Indian Constitution, which states that the state shall not deny to any person equality before the law or the equal protection of the laws within the territory of India. The first expression, equality before the law, which is taken from the English common law, is a declaration of equality of all persons within the territory of India, implying thereby the absence of any privilege in favor of any individual. The guiding principle of the article is that all persons and things similar circumstanced shall be treated alike, both in respect of privilege conferred and liabilities imposed. Equality before the law means that amongst equal, the law should be equal and equally administered, and that like should be treated alike. Hence, it forbids discrimination between persons who are substantially in similar circumstances or conditions. It does not forbid different treatment of the unequals. The rule rather is that like should be treated alike and that unlike should be treated differently. The same or uniform treatment of unequals is as bad as unequal treatment of the equals. As a matter of fact, all persons are not alike or equal in all respects. Applications of the same laws uniformly to all of them must distinguish between those who are equals and to whom they must apply, and those who are different and to whom they should not apply. Article 14 prohibits class legislation but does not forbid classification, which rests upon reasonable grounds of distinction. The principle of equality does not mean that every law must have universal application to all persons who are not, by nature, attainment or circumstances, in the same position. The varying needs of different classes of persons requires different treatment. Reservation is a policy designed to redress past discrimination against lower classes and minority groups through measures to improve their economic and educational opportunities. Reservation is an attempt to promote equal opportunity. The justification for reservation is to compensate for past discrimination, persecution or exploitation by the ruling class of a culture or to address existing discrimination. The principle of affirmative action is to promote social equality through the preferential treatment of socio-economically disadvantaged people. Moreover, the basic aim of reservation is to create social equality. Social equality is a social state of affairs in which all people within a specific society or isolated group have the same status in certain respects. At the very least, social equality includes social rights under the law, such as security, voting rights, freedom of speech and assembly, and the extent of property rights. However, it also includes access to education, health care, and other social securities. It also includes equal opportunities and obligations, and so involves the whole society. Indian Constitution is one of the best and largest written constitution of the world. Article 14 of our Constitution is itself soul of Indian Constitution, and even Article 22 is secondary to it, because what is the meaning of life when there is no equality? Indian reservation system has been a major success in improving the position of the backward classes, and past decades have shown remarkable development in position of backward and oppressed classes in India. Though our reservation system is an outcome of huge amount of research by commissions and government agencies like Mandal Commission, etc., but even then, somewhere our system is lacking on the applicability part. Also, some faults are there in identification of the backward classes, because despite of giving so many years of reservation, their position have not been developed. It is now sought to be contended by the Learned Council for the Appellant that the tenancy courts had no jurisdiction, and therefore the order of restitution also has no force. If we accept the contention of the appellant that the order passed by the tenancy courts at this instance are without jurisdiction and void, then in equity the respondent should be put back in possession of the land in question so as to obtain status quo ante, because the appellant himself obtained possession of the land by executing order of eviction passed under the Act at his instance. we are satisfied that equitable relief of the nature asked for in the suit in question should not have been granted in favor of the appellant so as to defeat the order of restitution passed by the revenue authorities under the Tenancy Act, whose jurisdiction under the Tenancy Act was invoked by the appellant himself. The appellant cannot be permitted to retain possession by challenging the order as being without jurisdiction, particularly when the jurisdiction was invoked by the appellant himself, only because the ultimate order has gone against him. The grant of discretionary relief, such as injunction being in the appellant, who is himself guilty of inequitable conduct, cannot claim such relief. The respondent filed a second appeal before the sales tax appellate tribunal, which allowed the appeal directing the commercial tax officer to delete the additions made towards transportation charges and agents' commission from the gross and the net turnover. The tribunal held that the purchases made by the agent from unregistered dealers are the purchases made by the respondent, and any expenses incurred subsequent to the purchase of raw materials would not be included in sale consideration flowing from the agent to the respondent. Aggrieved by the order of the tribunal, the appellant filed a tax revision case in the High Court of Andhra Pradesh. The High Court, without going into the merits of the case, dismissed the revision on the summary ground that the transportation charges and agents' commission were incurred subsequent to the purchase of the raw materials, and the said charges therefore do not represent the sale consideration which had passed from the buyer to the seller, is a finding of fact aggrieved by the order passed in the revision by the High Court of Andhra Pradesh. The above appeal by way of special leave petition was filed by the state of Andhra Pradesh. The basic facts which are not in dispute before this court is that the appellant came to be selected for the post of stenotypist in Hindi in PWD following a regular process of selection in pursuance of an advertisement. Under the terms of the advertisement, candidates were required to possess a minimum typing speed of 80 words per minute in taking Hindi shorthand and 25 words per minute in Hindi typing. The appellant qualified in the selection process and was duly appointed. Though the appellant was placed in terms of the office memorandum on a temporary basis, it is not in dispute that the appointment was against a substantive vacancy after a regular process of selection. The complainant sought to question the process of selection by levelling allegations of irregularities against the appointing authority to the Chief Minister. Following this, an inquiry was held by the Additional Commissioner in which the complainant was called upon to participate. Significantly, the appellant whose appointment was being questioned was not associated with the inquiry. Based on the report of the Additional Commissioner, a conclusion was drawn so that the appointment was improper, and accordingly, on 27 July 1999, The appointment was cancelled. Learned counsel for the opposite party number 2 has further submitted that admittedly the revisionist has not produced the high school certificate as required by Rule 12. The document on which the revisionist is relying is a photostat copy of the high school mark sheet in which the date of birth of the revisionist is mentioned. However, it is not disputed that the original mark sheet was also filed by the revisionist at the appellate stage. The submission on behalf of the opposite party number 2 is that the high school mark sheet cannot be equated with matriculation certificate when Rule 12 requires that there should be matriculation certificate, then any other document cannot be substituted in its place. The mark sheet is a document which states the marks obtained by a candidate in different subjects. It is not a certificate certifying any fact. According to him, in the absence of a high school certificate, the board and the first appellate court rightly relied upon the date of birth certificate issued from the high school first attended, in which the date of birth of the revisionist is mentioned as 14.03.1987. The occurrence is of the date 02.05.2005, and as such the revisionist was above 18 years of age at the time of occurrence, and both the courts below have therefore rightly declined him to declare as a juvenile. It has also been submitted on behalf of the opposite party number 2 that the subsequent criminal case in which the revisionist was declared a juvenile and the order became final was in fact a manipulated case. The FIR of that case was knowingly got lodged against the revisionist, in which revisionist made appearance, and on his application the board declared him juvenile. When we are dealing with this question of language, all languages are important. In my opinion, I will not say that Hindi is not important or the regional languages. In fact, we should provide opportunities for the promotion and cultivation of all languages in our country. In this connection, I would say that while there should be a common language, it will take